Just want to highlight for our participants a little bit of a philosophical difference that I think is clear between a plaintiff side approach and a defense side approach that I think was implicit in the way that Sean and I talked about the issues that are going on presently. For a plaintiff, it's really about trying to put forward a framework that shows that there's an effect that occurs, and that effect is going to be common across the class. And on the defense side, the story that's being put forward is often it's a complicated world out there, and different members of the class are having transactions in different ways, and different things are happening, and there's lots of variation that can be observed in the world. And as a result, arguing that the plaintiffs need to break things down and look at those smaller groups or even individuals. And for the plaintiff, the challenge is to say the data won't let you estimate effects based on an individual point. These effects can be shown using a collection of data, but they're common effects. The framework says they're going to affect everybody, and that has to be persuasive. So a lot of difference between these cases where Sean has mentioned, like batteries and ODD, where the judge rejected it, and cases like, say, high tech, where the judge certified a broad class of employees who are affected by collusive conduct, is whether the framework is persuasive and the arguments about the statistical analysis are put forward in a clear way such that the judge can recognize what is this really showing, what does it need to show. And that tends to be what determines whether the plaintiff side or the defense side succeeds.
Wonderful. Thank you so much again to Mr. Philip Johnson. Let's move on now, Ms. Natalie A. Fleming-Nolan. Any final thoughts from you?
Yeah, I mean, I've really enjoyed the presentations from Philip and Sean, and I think they've been really informative. I think that the economic piece is a very important part of antitrust litigation. But you know, as the Supreme Court found in Italian Colors, even though it's a key issue in antitrust cases to have economic analysis, that doesn't mean that there can't be individual arbitrations of antitrust claims. And so I think that as parties are, and I tend to work with defendants more than plaintiffs, but so from that kind of defense lawyer perspective, I think thinking through contracts and provisions and thinking about ways that parties can incorporate enforceable arbitration and class action waivers into their contracts is a way to help with some of the litigation costs that is associated with class action litigations. But keeping in mind that particularly in regards to antitrust, there are these issues I mentioned related to market-wide harm that may make that more difficult in certain circumstances, but it's still worth thinking hard about and trying to have fair and enforceable provisions in the contract.
Wonderful. Thank you so much again, Ms. Natalie A. Fleming-Nolan. And finally, in the few moments we have left, any final thoughts from you, Mr. Sean Durkin?
Yeah, I think I think the way I've tried to structure my remarks is simply to kind of point out that that when you're trying to think about asking a judge not to certify a class, that it can be helpful to think about the public policy implications of that decision, and to think about what you're asking the court to do. And the best way to go about that is to try to tell a sort of a simple and compelling story about why the effect of the challenge conduct is likely going to be small and likely to have not affected a non-sizable portion of the class members, and that trying to tell that sort of simple, compelling story can be much more effective than spending a lot of energy trying to argue that the plaintiff's damages expert is flawed, they should have done it this way, and those sorts of things. That the kind of simple, compelling story can be more effective, particularly in light of what you're asking the court to do if you're trying to defeat a class.